This week on Rochelle's Daily Wire Video Edition, we have a wonderful decision out of the Eastern District of Virginia that would make a marvelous final exam question in a law school class. Essentially, these decisions tell us three things. Number one preference cannot prevent a second preference from being a preference. Number two, a joint check agreement itself can be a preference. And therefore, in some circumstances, a joint check agreement won't prevent a contractor from receiving a preference. Here's how the case came down, and what we have was first a decision in July 2018 by bankruptcy judge Kenny in Alexandria, Virginia, and he was just upheld in the district court in the Eastern District of Virginia. So here's what happened. There was an owner of property that was under construction. The owner typically paid the general contractor, who in turn paid the subcontractor. But, as often happens, the general contractor ran into financial difficulty and was behind in payments to the subcontractor. As a result, the subcontractor said, "Oh, look, I'm going to stop working and delivering goods until I'm paid." So they entered into a joint check agreement, and what that amounted to was that the owner began writing a check jointly payable to the general contractor and the subcontractor. They had the general contractor endorse the check, and then it goes to the subcontractor who gets payment. Now, according to the Fourth Circuit in a case called Mid-Atlantic, an arrangement like that, a joint check agreement, is a perfectly good way for avoiding a preference, because the payment is not a payment by the bankrupt general contractor, it's a payment by the owner, and because it is not the debtor's property, that is to say, not property of the general contractor, it's not by definition a preference. But guess what? In this particular case, the joint check agreement was signed right smack in the middle of the 90-day preference period. And as a result, bankruptcy judge Kenny, affirmed in the district court, held that the joint check agreement itself was a preference because the general contractor gave up the right to receive money. That, of course, made the payment on the joint check a walkover preference. This case is, we're betting, going to be appealed to the Fourth Circuit. And when that decision comes down, maybe about a year or so from now, we're going to have some important law, in particular if they reverse. But I'm guessing there will not be any. You can read more about this case called Henry Truman in my column on the ABI website on the 31st of May, where you'll find a wealth of other information valuable for those in the bankruptcy community. Until the same time next week, I'll sign off and wish that those of you in the bankruptcy community will soon have an end to the allergy season and to the tornado season.